Okay, as promised, 11:02. I appreciate there are still people coming in, but they're only going to miss my opening, so that's not so important. Can I firstly welcome you, as always, to the latest in the Corner Stone Barristers Housing Team webinar programme for 2021. We're dealing with public sector equality duty, just to worry you, and residential possession claims. And it's a subject, of course, you may have been lucky enough to attend either a course last year that was done on homelessness in the PSED, where 5 members of Chambers dealt with that. And indeed, Emma, Ryan, Rucci and myself dealt with one last year on this same subject as well, although, as we'll see, things have moved on since then. This is, as I say, part of the series we're dealing with a whole range of housing issues. Some of you may have seen one that we did in June of this year, where Tara, Olivia, Christina and Rowan dealt with possession proceedings. Where are we now? And indeed, the next one is on the 2nd of November 2021, where Kuljit, Alex and Rowan, as far as I know anyway, are dealing with the question of antisocial behaviour, closure orders and community protection notices. And lastly, in terms of the plugs, please note that Housing Week starts on the 11th of October, and we're doing a webinar a day for that week. So you'll be getting details of that, if not already, very shortly. In terms of today, I'm going to be starting off. You see me, unfortunately, on the right, and then Rucci will be taking over from me, followed by Ryan finishing off. We're all people who have been involved in cases involving the public sector equality duty, including in possession claims. So hopefully you'll find this informative. And an obvious starting point, of course, is the Section 149 provision itself, which doesn't sit there in its entirety, but the public sector equality duty, which has predecessors in other legislation, such as the Sex Discrimination Act and the Race Relations Act, is, as you can see, really set out at Section 149 of the Equality Act 2010. It's particularly subparagraph 1, and there are those 3 strands of it. Now, of course, they may not apply in every case, although, as Rucci will discuss when she talks about the problems with pleadings, it's very rare for defences to pick out what they're complaining about. Are they complaining about a failure to have due regard to eliminate discrimination, to advance equality of opportunity, to foster good relations? And she'll be dealing with those issues. But that is what the duty is. And one of the crucial things you'll see there is from the first sentence, which has been put in pink, which says, of course, the duty is to have due regard. And as we'll see throughout this webinar, it's not a duty to achieve a result. It's to have due regard. It also follows from that is that it's very different, although there is an overlap of sorts, with discrimination and the question of proportionality. And it also follows in a sense that it's not something which, if you breach, you're liable in damages, where, of course, if you discriminated against a tenant, for example, you could be liable in damages. So Section 149 sets out those possible 3 requirements. And of course, that applies, if we have a look at the next slide, to people who have a protected characteristic. Now, what you'll see as we go through this webinar is that the main one that we're talking about is disability. But there's no reason why it can't be any of the others that you see there in front of you. And of course, that would mean that somebody would, for example, an officer considering whether to issue a warrant, or an officer considering whether to issue proceedings or to serve a notice seeking possession or a notice to quit, would have to consider a relevant protected characteristic, whether it's disability or age or sex or religion or belief and so on. So there are those protected characteristics, although, as I say, case law has suggested that it's disability that particularly is pleaded in defences and is raised, although I have, as I'm sure the other 2 have, come across other protected characteristics. Looking at the next slide, what we see in relation to this matter is that it's heavily litigated, which is great for us and great for our bank balance, but unfortunately it's not always very impressive for people who are having to fund such actions, particularly if the claimed breach of the public sector equality duty is hopeless. Now, you have a series of cases there. And what I would say about those very briefly, because they'll come up as we go throughout this seminar. The Taylor and Slough case is one of Rucci's cases, so I'll probably now get it wrong, and you'll see maybe Rucci later squirm. But it's an absolute ground case where there was a secure tenancy, and the tenant in that case lost the appeal against the possession order, and it was found that there was subsequent compliance. It's worth reading because it is one of the more recent cases and is helpful in that respect, but also worth reading to show the nature of the opposition. And as you might imagine, in an absolute ground case, the public sector equality duty acquires a greater role where otherwise there may be no other defence, where of course in a discretionary ground case, you're going to be dealing with questions of reasonableness in any event. Hertfordshire and Davis is not the main case that I did with Tara in this matter for Hertfordshire, but there was a challenge to the permission to issue a writ of possession, having got up to the Court of Appeal and back. And there was a complaint, there was a procedural problem with that. But as an add-on, I think it's fair to say there was an attempt to introduce the public sector equality duty and it didn't get off the ground. Luton and Dodana is a case which concerns ground 17 of the 88 Act Schedule 2. It's a misrepresentation case, therefore, and it's a case which I think was before Her Honour Judge Bloom, first instance, went to the Court of Appeal. The Housing Association succeeded at the Court of Appeal, and the Supreme Court are in the process of considering a permission to appeal application from the tenant. But it was, as I say, a discretionary ground case, and it was a question of whether it was highly likely that the result would have been the same if there hadn't been a breach of the public sector equality duty, where there had in that case. TM and Metropolitan, I won't say much about because we're in the Court of Appeal on this, myself and my junior, Liam Farnham from Fenner's Chambers. We're in a court of Appeal on this on the 3rd or 4th of November. Suffice to say, the two issues really being raised there, which will come up later in this webinar, are firstly, the availability of retrospective compliance with the public sector equality duty, and the question of whether it made any difference anyway, such that a breach doesn't have the effect of stopping the possession claim. Both of those issues Ryan will be dealing with at the end of the seminar. Forward and Aldwick was a breach, was an accepted breach of the public sector equality duty, and again was a highly likely case. In other words, the tenant was unsuccessful in arguing it made any difference at all, and therefore didn't succeed at the Court of Appeal. London and Quadrant and Patrick, if you are going to read any case, I think this is the case that still is useful to read. It does set out very neatly the different issues that are relevant to the question of the public sector equality duty. And from recollection, and I'll be corrected if I'm wrong, I think it was paragraph 42 in particular of Mr. Justice Turner's judgment that said that, but we'll be dealing with that later on. And lastly, but of course not least, Rucci and I dealt with the case of Powell and Dacorum Borough Council, where we didn't have to do much. It was an attempt to argue questions of public law, but in essence, it's in relation to a stay of the execution of a warrant for possession. In essence, it didn't get very far, and it was an important case for reasons which I won't spoil the next presenter's talk on why Powell was important, but it was important because of a contextual issue. So those are the kind of cases that we've had. And what I really want to make clear is that for those of you who have faced these kind of applications and these defences, and indeed the skeleton arguments that thereafter follow, you'll find a lot of cutting and pasting, and a lot of that cutting and pasting that takes place involves the case of bracking. Now, bracking is an interesting case in many respects. It was to do with a challenge to the closure of the Independent Living Fund, and therefore concerned issues of national policy. It's also important, as will be seen later, that Lord Justice McComb, who set out some basic principles of paragraph 25, was also in Powell and Dacorum. And therefore it's important to see from that point of view. But it's also cited, as I say, again and again by defendant lawyers as indicating that these are the proper approaches to the PSED, and woe betide anyone who doesn't comply with them. What we'll see by the end of this session is that it's not quite as simple as that. None of that is to undermine the public sector equality duty, which is an incredibly important duty and where possible should be complied with. And I think it's always important to set that as the basic approach. One should try and comply with it. One should try and consider whether somebody's disabilities have impacted upon their behaviour, or whether they would be particularly in difficulty were they to be homeless and so on, or whatever other protected characteristic. But it doesn't always mean that it represents a defence. And you'll see from a few principles that Lord Justice McComb, I'm sure there are more than ideas, although he's retired now, so maybe not, doesn't matter so much, that the decision maker must be aware of the PSED. Well, I think what we often say in housing is that a good housing officer who is just dealing with a case fairly and conscientiously will probably comply with it in any event. And there is good dicta elsewhere to suggest that it is possible to comply with the PSED, even if you've never heard of it or haven't got round to reading section 149 of the Equality Act 2010. There has to be a proper and conscientious focus on the statutory criteria, not a tick box exercise, not a standard form of words in a homelessness review decision, but a proper look at the statutory criteria and whether they apply, and if they apply, what impact, if any, that would have on the decision making of the public body or the body exercising a public function. It's helpful, obviously, to know that you've actually can show that you've complied with it. Now, that doesn't mean you have to do an assessment for every decision you make, but if there is a clear record of your decision making to show that, yes, we did contact the GP, we did have a chat with a mental health nurse, we did try to bring together a number of agencies, that kind of thing may, of course, help. And it's something for you to do. It's not something, when I say you, of course, I mean the public body or the body exercising a public function. And therefore you can't delegate that. And it should be complied ideally in advance. And obviously all I would say at this point, because Ryan will deal with this, is that it probably isn't a problem if it's not, but you should certainly aim to deal with it in advance. And lastly, and I think I haven't overrun my time, which is quite impressive for me, I have just put a picture of a judge in a funny outfit. What I wanted to say from Patrick, not only is Patrick an incredibly important case and a very helpful case if you wanted to get a feel for public sector equality duty issues, it's just what is actually said by Mr. Justice Turner in that case, where he said issues concerning the parameters and content of the PSED and its statutory predecessors have given rise to a plethora of decided cases, and we've seen some of those, the abundance of which is, at least in part, attributable to the elusively broad terms in which it has been cast. And all he's really saying there is that when one's looking at the question of due regard, it is very difficult to be precise. It's very difficult to say to a housing officer, for example, you must do X, Y, and Z. You can certainly suggest things that would be helpful, suggest things that would comply, but one can always think of other things. And therefore, it's difficult to ever say, I can 100% with 100% certainty say that I have complied. But certainly what you can do is make sure you're alive to the issues and you're alive to their potential impact on the decisions that you're having to make, as I say, whether issuing a notice, issuing proceedings, deciding to go for an absolute ground rather than a discretionary ground, going for a warrant, or whatever that decision is. But it's not, as I say, a very clear process, although hopefully by the end of this morning, you'll get a better idea of what you need to do and what the law is. So stopping there, you'll be glad to hear, I'm going to pass on to Ruchi, who is going to go on to deal with further issues concerning the application of the PSED. So Ruchi.
Thanks, Andy. So yes, I'm going to pick up from where Andy left off, and fair to say that Andy's obviously presented a very neat picture of what the various cases say, and in some respects one would think that that's sort of the end of the matter, but the reality is that the PSED remains a somewhat difficult and troubling issue for both landlords and tenants, notwithstanding the very large number of appeals and indeed court decisions that Andy's run through already, including, as you have noted, a large number of them were from the Court of Appeal, and they're all fairly recent. So the first thing I want to look at is why the PSED is still causing such an issue. And the easy answer, perhaps, is that the PSED, as Andy mentioned, is commonly pleaded as a defence to possession proceedings. And indeed, it's a point that is often pursued further in appeals up to the High Court and Court of Appeal. Now, on the pleadings point, and in my experience at least, it's quite interesting because the PSED is often included as sort of the last or final throwaway point that's always pleaded in the alternative. And it's only when you get to the trial, or indeed even the appeal in some of my cases, that it takes on a much larger significance because none of the other points are sort of made out on the factual evidence, etc. And then similarly, also on the pleadings point, and again, this I feel like I'm repeating Andy a lot, but the pleadings are not properly particularized. So Andy mentioned at the outset what the 3 equality aims were of section 149, and the duty is to have due regard to one or more of these equality objectives. So it's actually quite a specific duty, but when it comes to pleadings and defences, it's never really said what an officer may have failed to do. All that is usually said is that there's been a failure to properly discharge the PSED. Now that doesn't actually mean anything, and often it's not until you get to the trial, or in fact closing submissions in the trial, or indeed the appeal, that you really get a proper sense of what it is said, what is said to be the breach in any given case. So there's the litigation problem, as I say, with pleadings, and the fact that these cases tend to be appealed, or this issue tends to be appealed a lot. But I think that rather begs the question. And so I think, speaking sort of again from my experience, there are probably 3 other reasons why the PSED is really causing such an issue, and they're all really linked to the very heart of what the PSED is all about. So firstly, the very concept. I mean, it's not something that can be explained with scientific certainty, and I'll come on to this in due course, but due regard is very open-ended. It inevitably opens itself up to highly subjective interpretations of what is, due in any situation or on certain facts, and this inevitably leads to arguments in court. The second difficulty then is around difficulties with evidence. So there's 2 elements to this. Firstly, the difficulties in actually obtaining evidence in the first place. Now, as Andy mentioned, the majority of these cases, I think pretty much all these cases that he mentioned, were to do with the protected characteristic of disability. So tenants are vulnerable, and they may be highly vulnerable, which pose real issues in terms of communication and engagement. So in many cases, an officer is simply in the dark as to what the relevant protected characteristic might be. That being said, I probably should flag here that if there are any red flags, or if there's sort of, if there's anything in sort of your communication or lack of communication with the tenant that makes you feel that there might be underlying issues here, there is a duty on you to make reasonable inquiries. So, do bear that in mind. And in a given case, if you're not hearing anything back from the tenant, you may, for example, just want to reach out and check with local support groups, or mental health practitioners in the area, to just see if the tenant is known to them. Now, the second aspect of this, of the evidence issue, is the fact that evidence is often changing, or always produced last minute. And that's something that I've dealt with quite a lot in the cases that I've had. So what tends to happen is that tenants, understandably often will not get legal advice until the last possible second. So that will be before the first hearing, or in fact, in many cases, it'll be, you know, the day before the trial. And it's only when that process is sort of kicked off that you will suddenly come to court all prepared for a trial. And, you know, only the night before you'll have been served a sort of a letter from a GP saying that so-and-so has been suffering with all these issues for a very long time. And that, you know, if they're made homeless, or if the eviction goes through, they will have particular difficulties dealing with that, etc., etc. So that's something that throws a sort of, you know, a curveball, because as you will all hopefully be familiar, the BSED is a continuing duty. So just because you've considered it once at the start of proceedings doesn't mean it stands sort of still, you know, your assessment does not stand still in time. And there is an obligation on you to reconsider where relevant new evidence changes the picture that you previously, you know, believed it to be. Right, so that's the second issue. And then coming on to the third one, and I appreciate only now that the, you know, the slide is in slightly different order than I thought it was going to be, but in any event, I'll proceed with, you know, my order. The third issue is this confusion with proportionality and discrimination in general. Again, or, you know, as housing practitioners, no doubt you'll be familiar with the general proportionality assessment, which is the last stage that you come on to when you're dealing with a defence based on discrimination. And again, you'll be familiar that proportionality is really an exercise where you sit down and ask yourself whether, well, firstly, whether there's a sort of a legitimate objective in pursuing the eviction. And if there is, then, you know, is the eviction the least sort of intrusive way of achieving that objective, or are there some lesser means that you can undertake to achieve that same objective? And then you then come on to carrying out an overall balancing exercise, you know, to see whether it's in all the circumstances, if it's fair to proceed with the eviction. Now, while many of these considerations overlap with what you need to do when you're having due regard in the PSED sense, they are not one and the same thing. So they're not completely interchangeable concepts. And that is one, you know, sort of one point on which some people tend to make an error, because the PSED is just, it's not simply, it can't simply duplicate what you've done for a proportionality exercise. And it is a bit more focused, because what you need to do as part of the PSED is actually consider the impact of your decision, so in this case, to commence eviction proceedings, against the relevant equality aim in the PSED. So one of the three aims that Andy flagged at the start, and usually it will be limb B, which is about fostering equality of opportunity between those who, share protected characteristic and those who don't. So it's about taking into account how this will impact on a person with this disability, and whether there's anything in your decision-making process that you can do to aid with that element of that person's, of that disability effectively. So having sort of set out that it is all still quite stressful and there's lots of question marks and sort of errors in how people go about the PSED, our very firm advice is that you shouldn't panic, because the PSED is not some horribly complex beast, and properly understood, it should involve a fairly straightforward exercise. And the starting point to understanding how the PSED should be properly discharged is really to look at its purpose. And Andy touched on this slightly at the start, but I will just re-emphasize, that while it can seem to be quite annoying because it keeps coming up in appeals, when officers are just trying to go about their jobs very conscientiously, the reality is that the aim of the PSED, and indeed the predecessor to the PSED, which was in various, individual legislations dealing with race and disability, etc., is that aim is quite an important one. And it is really about embedding equality considerations across all public decision-making, so as to actually counter and, at the decision-making stage itself, counter any inequalities that might arise because of certain protected characteristics such as race or disability or gender. So it is very important, but that does not mean that it trumps everything else. And I just want to unpack that a bit in terms of, what really the PSED is all about. And there's three things that I want to sort of take away from the purpose of the PSED. So the first aspect is to bear in mind, as I've said, that the PSED is about process and the decision-making process. It is only one part of your decision-making process, and it absolutely does not trump all other considerations. Now, second, and related to that, it is not what is a so-called target duty. So it's not about achieving a specific outcome in any given case. It is really just about making sure that you've thought through the implications from a PSED perspective when you're coming up with, when you're coming to your decision of taking X and Y's step, whether that's the issuing of a notice or indeed commencing proceedings. Just because an individual has a protected characteristic, it does not mean that you can't actually commence possession proceedings. It just means that you need to think about it. So as I say, it's not about the result, it's just about the process. And then the third point on this that I just want to stress is that the courts have confirmed that substance will trump form when it comes to the PSED. So where you have sat down and conscientiously thought about a tenant's disability and how that might affect your decision-making process, that will, in cases, particularly where it's been properly evidenced, that will override any generic form filling or, box ticking exercise. And I think this is a point that was made quite clear and sort of re-emphasized by the courts in the Slough Borough Council and Taylor decision that Andy referred to. So in that decision, well, there were several issues, and I'm sure Ryan's going to touch on, might touch on one of them. But in terms of substance over form, one of the interesting things that came out of that decision was that the officer in that case had mistakenly filled out a sort of PSED form, a pro forma form, on the wrong basis, and had ticked the box that said that the tenant did not have a disability when it was clear that the tenant did have a disability. So this took on, quite an important role in the arguments on the other side, where it was alleged that the officer had not had proper consideration of the PSED. But that was dismissed both in the High Court, both in the County Court and the High Court. And the reason was because when you sat down and actually looked at the other contemporaneous evidence in the case, it was abundantly clear that the officer had conscientiously looked at and considered these issues. So, for example, there were email records where it was seen that the officer had made all these inquiries of, local support agencies, etc., to try and ascertain whether the tenant was known to them, because she hadn't had, she wasn't getting any responses from the tenant at that time. There was also evidence to show that she had actually, as soon as she'd seen the medical report of the tenant's disability, she had started making inquiries about whether there was any way that the tenant could be moved to supported living accommodation. And indeed, in the year that all of this was going on, all the antisocial behaviour and sort of the flat being used for drug use, etc., she had actually made 2 or 3 visits to the tenant at home to try and talk through all the issues, to see what other support she could provide, and indeed sort of to explain the consequences of behaviour not changing. And so when you look at when the court considered all that evidence in the round, it was clear that the duty had been complied with in substance, and it didn't really matter if a form had been filled out on the wrong basis, because it's not about, as I say, a box ticking exercise. And this brings me back to the point that Andy's already made, where which is actually that if with most officers, where you have conscientiously just done your job the way you're sort of trained to do and the way you no doubt do, that in most cases will automatically have the effect of discharging the PSED as well, even if you haven't thought about it in those terms. Although obviously it is advisable to give that training at the outset, and to make sure that officers do know what they need to be doing in any given case where there are issues raising protected characteristics or individuals with protected characteristics. So coming on then to the concept of due regard, and I did mention this, that I would come back to this. This, as I say, this is not an exact science. What is required will just ultimately depend from case to case, and it will differ from case to case. And I think that's one of the reasons why this issue is, the PSCD is litigated so much, because it does involve sometimes subjective judgments, and individuals will, tenants will disagree, and indeed tenants' lawyers will disagree with what an officer considers to be due in any given situation. That being said, I just want to emphasize here that, and this is sometimes does cause confusion in practice, I think, but the courts have confirmed that when you are looking at the issue of, for example, disability, what will be due in any given situation will be affected by what else is going on in the case. So not only are you entitled, but in fact, you're required to take into account all the countervailing or competing factors in your case. So on the one hand, you'll be looking at the protected characteristics, to say it's disability, and you'll be thinking about how your decision affects sort of the aim to foster equality of relationship, equality of opportunity, sorry. But on the other hand, you are very much entitled and mandated to use in the balance sort of what else is going on. So, how a neighbor is being affected, how long has this activity been going on, what other steps have you taken? And to that extent, at least, there is an obvious overlap with the proportionality exercise, which is why, officers will usually do all of this together, sort of the proportionality element and the PSCD. And as I say, there are clear overlaps, but as I've also mentioned, they are two different questions. So just be careful not to entirely conflate the issues. And it is often helpful to sort of record separately, even if it's on the same form or same document, that you've had consideration of the PSCD as well. Linked to this concept of what is due regard is the sort of overarching factor, I would say, and perhaps this is the key thing that's come out of the recent, all the recent cases that Andy mentioned, is that the PSCD is an entirely fact-sensitive and context-specific exercise. Now, again, a lot of cases have talked about this, but just picking up perhaps on the Patrick case, which Andy mentioned, was the one case that you should read if you're not going to read any of the others, because it helpfully summarizes all of the other principles that have been gained from the other cases. But what I will just say about Patrick is the facts of that are quite interesting on this sort of fact-sensitive subject and what is due regard in any given case. So in that case, there was no mention of any disability previously, and indeed there was nothing to suggest that the officer needed to make inquiries in that case. But what happened was that I think a day and a half before the hearing, for the first time ever, the tenant adduced all this evidence of a disability. But the local authority officers considered this and pressed ahead with the hearing. And it was only then on appeal that it was effectively argued that, given that they had this new evidence, they should have, sat down and had properly considered the PSCD and properly considered whether they should proceed with the proceedings. And there's interesting commentary on this in the judgment of Patrick from Mr. Justice Turner, because what he sets out really is the fact that what is due in any given situation will be fact sensitive. So where you've got new evidence at the 11th hour, you can't expect, or officers are not expected to discharge the PSCD in the same way that they might have done if this evidence was available to them at the start of the whole process, say prior to issuing proceedings. So the facts of any given situation will impact on how you choose to discharge the PSCD. And in this specific case, the judge accepted effectively that it was enough for the officer to just review this evidence and, make a decision themselves to just proceed, rather than sitting down, filling out another form or filling out another document saying that that's what they had done. And then just a final note on this slide is that once you have considered the BSED, a court is not going to intervene on the subject of, or the question of how much weight you give to the duty. So that the matter of how you balance the BSED into your overall decision-making process as to what you effectively do, i.e. whether you continue possession proceedings or not, that will be a question for you. All a court will do is to assess whether you have considered the BSED in the first place. They won't interfere to say, well, actually, in this case, you should have given it more weight or not. And so to the extent that that's what the defendant is arguing in any given case, that's something that can be easily dismissed. And given that Andy talked about bracking and sort of tying the thread together with everything that I've said, what has been really helpful in terms of countering all the pleadings that have copy and paste, from the judgment of bracking, is that the judge, Lord Justice McComb, who gave the leading judgment in bracking, actually also gave the leading judgment in the Powell decision that Andy mentioned that we were both in. And very helpfully, he himself said that lawyers need to stop reading bracking as though, firstly, it's part of the statute books, and indeed to simply apply the bracking principles to cases where they're just simply not relevant. Because the reality is, as I've said 4 or 5 times now, this is all fact specific. And just because, a macro policy decision will require all the things that bracking said it required, doesn't mean that the same considerations applied in the individual cases of, that local housing authority officers need to make in any given case. So on that note then, I will pass over to Ryan to discuss the implications really of what happens if you get it wrong the first time round.
Thanks very much, Ruchi. And I think the overall message to derive from Ruchi's contribution is that it really is about substance over form. But what I might encourage you to all think about is, well, it can't hurt but to have the form in place for the purposes of an audit trail. So before we get to the stage of retrospective compliance, in order to encourage your clients to get it right in the first instance, it's not a bad idea to have a pro forma that demonstrates you've had regard to the public sector equality duty and properly considered Equality Act considerations. And indeed, central government, when they are introducing or amending legislation, have a procedure they go through in every case where they think about the equality impacts of any individual piece of legislation. So similarly, what I suggest is that as a social housing landlord, you have a pro forma, you have a procedure that is all about the equality impacts of a particular decision, whether that be instituting the proceedings for possession or serving a notice or claiming an injunction. Whatever the step is, there ought to be a form which you as a lawyer and your client as the housing officer sit together and fill out, that demonstrates for the court that you have had regard to the necessary factors within Section 149 of the Equality Act. And it's a good discipline because it forces you to apply all those steps that you've been doing anyway as an excellent housing officer, but to set it out in a single document that you can then rely upon before the court when there is the inevitable challenge saying that you haven't complied with the public sector equality duty. So absolutely right, we're all about substance, but it can't hurt to have the form just so that you've got an audit trail of your decision making and so that it's much easier for us as lawyers when we're representing your position at court. Now, I feel a little bit conflicted about talking to you about retrospective compliance because, of course, we all hope that you get it right at an earlier stage and you don't have to consider, well, what happens when it all goes wrong. But it is important for you to know that the higher courts are very reticent to say that a breach of the public sector equality duty is somehow a trump card. It really isn't, for all the reasons that Ruchi has eloquently explained. So, well, what does the court do when it all goes wrong? Well, it looks to see whether you have complied now. So at the time of trial, looking at TM and Metropolitan Housing Trust, have you now complied with what was expected of you at an earlier stage? Have you, in your witness statement, for example, for trial, had due regard to the need to treat a disabled tenant more favourably than a non-disabled tenant, and what are the factors you've taken into account? And if you do that in a conscientious and full manner at trial in your witness statement, even if you haven't done it previously in the equality impact assessment that I've referred to before, then the court will have some sympathy with that position. And so long as it is genuine and reliable, and not some sort of ex post facto retrofit, which will be obvious to everybody upon reading such a witness statement, then the court will give that weight and will ultimately conclude that the duty has been discharged. Now, Ricci's case of Taylor and Slough Borough Council, just on the previous slide, sorry, is also very important because it sets out in terms that a breach of the PSED can be cured. So the judge says he does not accept that an argument that a breach cannot be cured, at least in the circumstances of this case, by subsequent compliance with the duty. So where there is no prospective compliance, it is absolutely possible to demonstrate at trial that you have complied, albeit belatedly, but that it is genuine compliance as opposed to simple box ticking. So Ricci's case is really important from that perspective because it is a very clear exposition from the Court of Appeal saying that there is no trump card and that you are able to comply at a later stage, even if you don't comply when you should have done. So moving to the next slide. What happens even if there is a breach of the PSED and even if there is no late compliance? Well, even then, the court is able to draw an analogy with Section 31(2)A of the Senior Courts Act 81. Now, it's important to say that that section is not of direct application to situations where you are defending possession proceedings. That section is aimed squarely at judicial review proceedings. And the question for the court will be, is it highly likely, but for the breach, that the outcome would have been the same? And that's what the court asks in judicial review proceedings when considering relief. But it's also important in the context of, say, possession proceedings, for the court to take the same approach by analogy, because again, it's the same point that we were hammering home earlier. It is a question of substance and not form. So for that reason, cases like Forward and Aldwick, and Lord Justice Longmore at the bottom of the screen, reiterates that just because there is a breach of the PSED, it does not necessarily follow that your possession claim fails. And indeed, quite the opposite. The court will be rigorous to scrutinise whether that breach was substantive. Would it have made a material difference, or was it simply a breach of form? I, unfortunately, have to go to the door to collect an urgent brief which has just arrived, so I'll let Ricci just take over for a moment.
Hi, I'm just going to hold fort while Ryan comes back. I'm just going to take a quick look at the questions that have been asked so far to see if there's anything that I can address there. I think Andy and Ryan have very efficiently answered these already. So if you'll just bear with us for 1 second. And Ryan's back already.
Sorry about that. I did warn Ricci beforehand that might happen. I was expecting an urgent set of papers, and I just knew sod's law that it would arrive as I was talking to all of you. So I am very sorry about that. Now, Section 31(2)A. Yeah, so the takeaway points are that it's not of direct application. It's generally about judicial review and public law decision making. But in cases like Forward and Aldwick, it's clear that the courts apply it by analogy. So it's an important tool to have up your sleeve, because the courts will consider whether, even if the duty was complied with, it would have had some kind of substantive impact on the case. So that's what I want to say about that. And then finally, Luton and Jordana. So even if there is a PSED breach, And even if the court carries out its by analogy section 31(2)(a) assessment, that may still not be the end, because of course what the court then has to go on to do is to consider all the factors that go to the reasonableness in a discretionary grounds case of an order for possession. And that isn't limited to an assessment of what was known about the individual's disability at the time that possession proceedings were instituted, but it is a comprehensive assessment of what reasonableness requires at the date of trial. So the message from Durdana and the cases on the previous slide is that even if there's been a breach of the PSED, even if the court has concluded that section 31(2)(a) can be applied by analogy and that there would be no substantive difference to the outcome where the duty to be complied with, there is then a further step of actually persuading the court that even taking into account what's happened up until the date of trial, it is nevertheless reasonable for the court to make an order for possession. So those are some of the things that I wanted to talk to you about in terms of retrospective compliance, to give you some comfort that just because your clients don't comply doesn't mean it's the end of the road, and the courts are very astute to saying that the breach of the PSED is not a trump card. And now I think we have 10 minutes for questions. So I shall open it to the floor.
Yes, I think, Ryan, we've, as Ruchi said, we had some questions which you and I have looked at as we've gone through and Ruchi was doing her piece. By the way, that's Ole Gunnar Solskjaer, just in case anyone's asking, like Ryan did.
I had no idea, I must have.
But that's my fault. But if people do have questions, please use the chat function, because I suspect you're automatically muted, so you may be kind of shouting at the screen now. Please use the chat function. I think what I would say, encapsulating everything that's been dealt with, particularly by Ruchi and Ryan, is it's something not to be scared of. It really is something not to be scared of. It's frustrating, but remember, it's also probably allied, certainly at first instance, with many other defences as well. It's not the only defence. It sometimes gets to be the only defence on appeal, like happened with Powell, for example. But remember, Powell started off with a trial as to whether, in fact, there'd been a breach at all of the suspended possession order in the normal way. It started off with allegations of discrimination, etc. So it doesn't at first instance, and it shouldn't at first instance, worry people. And also, just to say in response to one of the questions which I answered, be a little bit careful about, and I know this happens in the criminal law as well with some cases, about giving the defence an opportunity to improve their case by telling them why their assertion of the PSED is hopeless. If you represent tenant lawyers, of course, put your fingers in your ears now. It's probably better sometimes to save it for trial. If that really isn't adding anything to the case, if it really is a hopeless argument, then you might as well leave it till trial, to be quite frank. And there's no point being pedantic and seeking a strike out of that paragraph of the defence or seeking further particulars. If there is a genuine issue there, which you think could be interesting, that may be when you ask a part 18.
Andy, I think Amita Makrani has asked whether one should write to tenants and ask them if they believe that they have a protected characteristic that's relevant, because it might not be obvious from the council's records. Now, I'll perhaps kick this off and then hand it over. As Andy's head movement's indicating, it's a double-edged sword, because of course the council cannot be expected, and it's set out in the Equality Act itself, to take into account something that it had no knowledge of or it couldn't be reasonably expected to know. I suppose the issue is that if individuals are in social housing, quite a lot of the time they will be there because they fell within one of the priority need categories, and that can quite often be because they suffer from a disability, for example. And so perhaps on one view, the council should be on notice that because of the nature of the tenants that they deal with, it's more likely that they might have disabilities than the general population, and so it can't hurt to proactively make the inquiry and front load it. It might also help to proactively make the inquiry because, of course, they may say something that reflects the true position before they go and see a solicitor who might, ex post facto, try and achieve some kind of disability diagnosis later down the line. Not saying that they're necessarily acting inappropriately in doing so, but that is something that can happen, and it's quite useful to have a contemporaneous note to show, well, actually, before you instituted proceedings, you made inquiries about a disability and were told from the tenant themselves that they don't in fact suffer from one. So it is a double-edged sword. I'll see what Andy and Ruchi think.
I mean, personally speaking, I think what Ruchi had said about a good officer complying with the PSCD is really what it's about. And I don't think it's a good idea to start saying, by the way, here are the 9 protected characteristics. Which one do you suffer from, or which one do you have? Because, for example, everyone has the protected characteristics of sex. But it may be irrelevant, what sex the person is. But in other cases, it may be fairly obvious that is the reason why, for example, they're receiving problems from the neighbour, and there may be particular issues there. So I wouldn't go out of my way to do that. And I would hope a good landlord would know the protected characteristic. And in any event, once they are made aware, they can then, as has been said throughout this session by particularly Ruchi and Ryan, they can then deal with it. Can I also, at the same time, before Ruchi comments on it, just also say very quickly in relation to 2 questions on the question and answer function, PSED isn't accommodation related. It's not about whether you've got a secure tenancy or a private tenancy or whatever. It's about a landlord either being a public authority, like a local housing authority, or exercising a public function, like in most instances, probably, and I underline probably, housing associations. So, for example, just being a licensee doesn't mean the PSED doesn't apply. If your landlord of that license is a local authority or housing association, it may well apply. Same with supported accommodation. And there may be issues of funding, as I've answered previously. And just very quickly at the end, the question about disclosing any pro forma of the kind that Ryan was talking about being helpful to have. Yes, it should be a public document. It should be part of the documents that you would disclose in the normal course of events. It's not meant to be an internal secret document. It's meant to be the product of your consideration of the case and sometimes your discussions with the tenant or the household member. Yes, I think it can be disclosed. There's nothing strange about it. I wouldn't see it as a get out of jail card, because the reality is whatever you say to a tenant lawyer, in my experience, they're still going to plead the PSED. And that's no disrespect. They're obviously acting on behalf of their clients and trying to do the best job possible, but it's not probably going to be the thing that stop that happening. Just finally, pre-action protocol letter. Yes, it's always a good idea to talk to the tenant, of course. And of course, it's always a good idea to comply with a warning that if they don't behave or if they don't stop defaulting on their arrears or damaging the property or whatever the problem is, the local authority or the housing association is considering going for possession and getting their feedback. And if it's a mandatory ground, you ought to be complying with Part 3 of the social housing possession claim protocol anyway. So I'm a big fan of protocol letters, and I don't see any reason why one shouldn't be sent out. So I think that's a good idea. So I'll shut up now and pass to Ruchi.
Thanks, Andy. Just on that last point, just reading the question, that last question about pre-action protocol letter, I'm not sure what's intended there, but it does say, would that suffice? And that's, I think, one part of it, but I don't think that would be the sort of, it depends from case to case. As I said, it's very fact specific, but if there are, if you do that, and if the tenant for whatever reason doesn't respond and doesn't even respond, doesn't attend any sort of meeting that you've set up, but that there are other sort of red flags or warnings in any given case as to why you think that actually the tenant might have a disability, in that kind of case, you might be expected to go one step further and try and make some other inquiries. But other than that, where there's no possible way that you could have been expected to know about a tenant's disability, for example, the courts don't expect you to go further. And that just ties back to, I think, the previous question we had about whether you should write to tenants, about their protected characteristics if you're not sure if they have one that's relevant to your decision regarding possession. Again, just, you know, just echoing what the others have said, I don't think that's necessary. And in fact, that's something that's made quite clear in the Patrick decision, where the court says, well, actually, if there's nothing to suggest that they have a disability and that there's no, you know, reasonable reason why you would have been alerted to it, then actually you can't just expect officers to sort of just sit down in a total vacuum and come up with hypothetical scenarios of what, you know, may or may be relevant in any given case. That's certainly not a standard that the courts will hold officers to. So I think you can feel fairly comfortable with just proceeding on the basis of the information that's actually provided to you and on the basis of any reasonable inquiries you've made where, as I say, there are any warnings or red flags. I am just looking to see if there are any more questions. I don't think there are.
I mean, I think because I need to get to court, so I won't leave my colleagues and friends in the lurch. Can I just thank everyone for attending? You know where we are anyway. Hope you've enjoyed it. What I do know is that these slides do go on YouTube eventually. And I think we do send out the slides, but I'll check with that, with those who kind of run things to see if that is the case. But I hope you've enjoyed it. If you have any constructive feedback, please feel free to email either Chambers or ourselves individually. And thank you very much for attending. It's much appreciated.
Thank you all.
Thank you.